So in the last class, we have discussed about the president, the governor, and the vice president under the part 5 of the Indian Constitution, that is the executive. We have discussed all thing about the election of the president, the qualification, the electoral college, what does it consist of, and the most important, we discussed the impeachment of the president. Yeah, impeachment of the president we have discussed. Then we have discussed about the Article 71, and then the most important, that is Article 72. We discussed the pardoning power of the president. How can the president either reduce or change, okay, the punishment that is given? And we discussed the Nirbhaya case. Then we discussed the UN Rao versus Indira Gandhi, the guideline which was laid down in Epura Sudhakar versus government of Andhra Pradesh, in which judicial review will be there on the on the pardoning power of the president if it does not follow the following thing, which were the application of mind, the order is malified, or it is arbitrary. In that case, that will not be considered to be a order, and it will be struck down by the Supreme Court. Then we discuss about the governor, the tenure of the governor, who he will submit his resignation. Okay, and then under Article 161, we discuss the power of the governor to grant pardon. Then we move to, after the governor, we move to the vice president of India, in which we discuss under Article 64. That is, the vice president will be the ex officio chairman of the Rajya Sabha, and he will act as the president during when the post of the president is vacant. And then we discuss the electoral college of the vice president, the tenure of the vice president. This all we discuss. Now today we are going to discuss with the Parliament of India. So the first and the most important thing that we must know, that the Parliament generally, for a common man, for a layman, the Parliament sorry, the Parliament for a layman, it is the only the Lok Sabha and the Rajya Sabha. When you will ask a layman that what is a parliament, they will say that it is the Lok Sabha and the Rajya Sabha. But the truth is that the parliament consists of the president, the Lok Sabha, and the Rajya Sabha. That is the Council of State, the upper house and the lower house. So whenever in any polity question, whether it is BHU, Clat, MSCT, or even in judiciary, whenever the question comes that the Parliament of India comprises of which of the following: A. President, B. Lok Sabha, C. Rajya Sabha, D. All of the above. So the correct option will be all of the above. The Parliament consists of the President, the Lok Sabha, and the Rajya Sabha. Now, Lok Sabha and Rajya Sabha, we know that it is the upper house and the lower house. Now, Article 79 of the Indian Constitution state that there will be a Parliament of India. There will be a Parliament of India which will be consisting of the President and the two House of the Parliament, that is given in Article 79. So as I have told you yesterday also, these are the just we have to know that what is being given in a particular article. If there will be any detailed discussion, definitely I will be doing it just like we have done yesterday. Now we come to the Rajya Sabha, that is the upper house of the parliament, also called the Council of State, which is a permanent house. Now permanent house means even in during the emergency or after every general election, before the general election, the president dissolves the Lok Sabha. That we will be discussing today only, don't worry. So the president dissolves the Lok Sabha before the general election or during the time of emergency. Also the Lok Sabha can be dissolved. But this Rajya Sabha, it is a permanent house. Rajya Sabha is a permanent house which cannot be dissolved at any time. Whatever may be the, even not before the general election and not in the time of the emergency. Also the Rajya Sabha cannot be dissolved. It is a permanent house, and the member has a term of 6 years, and 1/3 of the member retire after every 2 years. That is, we all know, that is a very common thing, that the Rajya Sabha is a permanent house. Okay, the tenure of the member of the house is 6 years, and 1/3 of the member retire after every 2 years. These are the things that we have to know from the examination point of view, that what is the tenure, whether the Lok Sabha can be dissolved or not. There is a question that whether the Lok Sabha can be dissolved or not, then the Lok Sabha can be dissolved, but the Rajya Sabha cannot be dissolved. So this is the upper house of the parliament, that is the Council of State, and it consists of 250 members, out of which 230 members are elected, okay, and 12 members are nominated by the president on the advice of the Council of Ministers, those persons who are excellent in the field of law, science, literature, craft, or space. Take the recent example, the controversy of ex and the former Chief Justice of India, that is Ranjan Gogoi. Okay, Ranjan Gogoi was appointed to the Rajya Sabha under this 12 nomination that is being done by the president on the advice of the Council of Ministers. So yesterday also I have told that Council of Minister, whenever we talk about Council of Minister, it includes the Prime Minister also. The Council of Minister also include the Prime Minister. So Ranjan Gogoi was nominated to the Rajya Sabha by the President, and there was a controversy regarding that he has been given a gift for the Ayodhya verdict and the Aadhaar verdict that he has given in the favor of the NDA government. So therefore that was controversy, but then Rajesh, in many of the debate and means for like the E time and the India TV time, Ranjan Gogoi appeared and he clarified it, that reason for why he accepted this nomination. So 250 member, a total of 250 member are there, out of which 238 member are elected and 12 member are nominated by the president. Next, we have the Lok Sabha. That was about Rajya Sabha. That you have to know that it cannot be dissolved. The tenure, the how many member retire after every 2 years, that is one third. And then you have the 250 member are there total, out of which 238 are elected and 12 member are nominated by the president. Then we have the Lok Sabha. The Lok Sabha consists of the 530, that is the maximum member who are elected from the different house as different state, and 20 member are from the union territory. 20 member to the Lok Sabha come from the union territory. Now see this line, I have written this line knowingly and intentionally, that if the president feels that there is lack of representation of the Anglo-Indian community in the parliament, he may nominate two members of the Anglo-Indian community. Now this provision is no more. We will be discussing, when we will be discussing the amendment, that time I will be discussing it in detail. By the 104th amendment, this provision has been deleted. By the 104th amendment, this provision has been deleted by the in the Indian Constitution, that the president cannot now nominate two Anglo-Indian. Just in the Lok Sabha, how we nominate, that means how we means the president nominate 12 members. In the Lok Sabha before 2020, the president was nominated two Anglo-Indian if he feels that there is lack of representation of the Anglo-Indian. But after the 104th amendment 2020, the president no longer nominate any Anglo-Indian community to the Lok Sabha. Now the seats are reserved for the scheduled caste, scheduled tribe in the Lok Sabha from every state, है ना? And then the Lok Sabha, unless dissolved midway, continue its tenure for 5 years. Now the dissolving of the Lok Sabha, that we will be discussing further in the further article. Don't worry. So dissolving of the Lok Sabha is done by the president, but that is done on the advice of the prime minister and the council of ministers. If the prime minister sees that he is not in a majority, okay, or he feels that there should be a re-election should be done, in that case the prime minister and his council of ministers will suggest the president that he or she should dissolve the Lok Sabha. On that case, the president will dissolve. But however, the general tenure of the Lok Sabha is 5 years, that we know. For the Rajya Sabha, it is 6 years, and this is your 5 years. Now, after every before every general election, the Lok Sabha is dissolved, and after the Lok Sabha is done, the general election is done, then new meeting of the Rajya Sabha is being held. So these are the time when the Lok Sabha is dissolved, that we will be discussing. So Article 79. There shall be a parliament for the union which shall consist of the president and two houses, to be known as the Council of State and the House of the People. As I have already told you in the beginning of this session, that the parliament not only consists of the Lok Sabha and the Rajya Sabha, it also consists of the president. So it is Article 79 of the Indian Constitution which discusses this, that there shall be a parliament which shall be consisting of the president and the two houses of the people. Now basically generally in the polity question, they don't ask which article it's of the Indian Constitution. Generally they ask this question, that the parliament of the India consists of which of the following. So you will be selecting president, council of state and the house of people. Very good. Now we move forward. Article 80. Article 80 is the composition of the Council of State. So we have discussed just before this the Rajya Sabha. Now we are discussing it in the article format, that the Council of State, that is the Rajya Sabha, consists of 12 members to be nominated by the president in accordance with the provision of clause 3. Not more than 238 representative of state and union territory. Okay, so 12 member will be nominated by the president, that we have discussed now. Ranjan Gogoi nomination to the Rajya Sabha, and 238 member will be from the state and the union territory. These are the two important under Article 80 that you have to know. Now see, the member to be nominated by the president under subclause A and clause 1 shall consist of person having special knowledge in the field of literature, science, art and social service. Now you don't have to remember this, just you have to have a basic knowledge that this 12 nomination that is done to the Rajya Sabha They belong to the field of literature, science, art, social service, and there are many things law also. Okay. Now this is very important. Article 82. Recently, you must have those who are following the Hindu and Indian Express, or those who are following the news. Those who are following the news, not only Hindu and Indian Express. You must have seen that. I guess yesterday or day before yesterday, the leader from the Bihar, that is Bihar Chief Minister Nitish Kumar, and Bihar opposition, that is I guess Tejasvi Yadav, yeah, RJD Tejasvi Yadav, and then many other made with the Prime Minister over the caste based census. Okay, over the caste based census, they want a caste based census in the country. Even your that AIMIN, that is Asaduddin Owaisi, and mostly all the opposition, they want that a caste based census should be done in our country, but the present government, that is the central government, is not ready to accept it. However, this is politics and they need the vote bank, so definitely they will be accepting. They are under pressure now. So why I have introduced this topic, because Article 82 deals with the readjustment after each census, and then here only we will be discussing about the central vista also. So what does it tell? That upon the completion of each census, the allocation of seat in the House of the People to the state and division of each state into territorial constituencies shall be readjusted by such authority and in such manner as the Parliament may by law determine. So after the census, we know that census is held in India after every 10 years. After every 10 years, census is held in India, and the latest census is 2021 census. But let's see, because of the corona, it has been delayed, and now they have all the opposition party have come with the caste based census. So that is another thing. So after every 10 years, the census is done. The last census was done in the last sorry, so 10 year. And the thing is that after the census is done, now whenever the census is done, that time the population of the country changes. Okay, whatever we are following 2001 census to 2011 census. So whenever we are following the census, that time what we are doing, that according to that, all the schemes and all the parliamentary that are representing the different constituency are being taken into consideration. Now recently what we should know, that now the parliament is being represented by the 1971 census. Okay, and it was made by an amendment that we will be discussing when we will be discussing the amendment, that this 1971 census will be taken into consideration up to 2026. After 2026, the 2021 census will be taken into consideration, as a result of which the government has introduced the central vista, a very controversial issue. You must have read, those who have were in Clat 2020, you must have read the central vista issue, the Delhi High Court judgment, the Supreme Court judgment. So it is told that after the completion of each census, there will be a readjustment in the number of seat in the House of the People. But however, by an amendment made during, I don't remember the government, in which government it was made, most probably it was in Indira Gandhi's government, that it was held that the census that will be considered for the allocation of seat will be the 1971 census, and this will continue up to 2026. After 2026, you can change the allocation of the seat. So now after 2026, we will be having the latest census of 2021, if the census happens in 2021. So as a result of which, the central vista is being made to accommodate more number of parliamentarians. Now that is Article 82. Now here also you don't have to remember Article 83, that is duration of the House of the People. Okay, you must remember the article as a law student, but the most important thing is that the most important is the duration of the House of the Parliament, and that is we have to know that that first is the Rajya Sabha. As we know that the Rajya Sabha is a permanent house, it cannot be dissolved. The tenure is 6 years, and for the House of the People, it will continue for 5 years until and unless it has been dissolved. And after the expiration of the 5 year, it will automatically get dissolved. Now, when there is an emergency, when there is an emergency in that time, for example, if the Parliament is going on, then in that time, what will happen? That in that time, the tenure of the Parliament, it can be extended for 1 year, not more than that. Okay, the tenure of the Parliament, that is the House of the People, it can be extended for 1 year, and once the emergency is over, once the emergency has ceased, okay, after that the Parliament should not be continuing for more than 6 months. Two things you have to know, that you know the Council of State and the House of the People, that you know. Another thing is that while there is a proclamation of emergency is in operation, okay, so at that time the tenure of the Parliament will be extended for a period not exceeding 1 year. For a period not exceeding 1 year, and then they told that the once the proclamation of emergency is over, after that it should not be more than 6 months for which the parliament tenure has been extended. These two things you have to remember. No, that is article number 83. So here generally the article is not asked in the polity question in the various examination. Generally you have to remember that during the emergency, these 2 points you have to remember: the 1 year extension and the tenure for 6 months after the parliament or when the proclamation of emergency has ceased to operate. Now, Article 85, that is session of parliament, propagation and dissolution. So the president from time to time, okay, president from time to time he will give the order for propagation or the dissolution or the summon to for the house. So he can tell that for example, after the general election is done, okay, once the general election is over, for example the 2019 general election is over, after the 2019 general election is over, the president will call the two house of the parliament to start working. That is the prorogue of the house of the either house. He can ask, he can dissolve the house of the people, because the Rajya Sabha is a permanent house, it cannot be dissolved. So he can dissolve the Lok Sabha, can be dissolved. Now, Article 89, we will be talking of the Indian Constitution, that is states that the chairman and the deputy chairman of the Council of State, which tell that the vice president of India shall be the ex officio chairman of the state. The Council of State shall, as soon as may be, choose a member of the council to be the deputy, and therefore, and so often as the office of deputy chairman becomes vacant, the council shall choose another member to be a deputy chairman. So we have discussed, while we were discussing in the vice president, I have already told you that the vice president of India will be the ex officio chairman of the Council of State, that is the Rajya Sabha. That is given in Article 89 according to the parliamentary system. Now the second state that apart from the chairman, that is the vice president, the member of the Rajya Sabha will also choose a deputy chairman, and the moment the deputy chairman seat get vacant, another deputy chairman will be chosen by the member of the Council of State, that is the Rajya Sabha. This is article number 89. Now, then we have article number 93. The House of the People shall, as soon as may be, choose two members of the House to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker become vacant, the House shall choose another member to be Speaker or Deputy Speaker. So Article 89 talk about the Chairman and the Deputy Chairman of the Council of State, that is Rajya Sabha. Article 93 talks about the Speaker and the Lok Sabha, Speaker and the Deputy Speaker of the Lok Sabha. When the time of the election of the Lok Sabha comes, the election of the Speaker comes, the party in power that has got the majority, they will nominate one name, and those who are in the opposition, they will also nominate one name, that this is my speaker, this is my speaker. Now the voting will be done, and definitely who is having the majority in the Lok Sabha, he will be that party will be getting his or her speaker. So many time you must have heard, many time in the Hindu, in the Indian Express, okay, even Lighting Dream has uploaded one blog on that, and in the various article of Live Law you must have seen the controversy regarding the speaker. Okay, many time it has been told by the various experts that the post of speaker should be either be removed, or the appointment, or the way in which the speaker is elected, it should be changed. Okay, because the person who is till 24th a member of Congress, and today 25th he became the speaker, does not absolve him from the what you will tell, the closeness that he or she is having with the Congress party, or whether BJP, whatever it might be, whoever is in the power. So the person who was till 24th of August, he was talking about Congress and doing work for the Congress. Okay, on 25th, he does not get absolved from all those things. So many times you must have heard and read about the controversy regarding the speaker. So those who are writing blog, they can write also blog on this. Those who are submitting blog to Lighting Dream, you can write on this also about the speaker issue. So Article 93 talks about the speaker, that is your for the Lok Sabha. Now, Article 100 talk about the voting in the House of the Parliament. Now this article you have to remember. This article is generally asked in the examination of the whatever examination it might be. So this question is generally asked that which article of the Indian Constitution talks about the voting power of the House. So Article 100 talks about the voting power of the House. Save as otherwise provided in this Constitution, all question at any sitting of either House or joint sitting of Houses shall be determined by a majority of vote of the member present and voting, other than the Speaker or the person acting as a chairman or the Speaker. The chairman or the Speaker or person acting as such shall not vote in first instance, but shall have an exercise a casting vote in case of equality of vote. So now what is this? You must have seen that the recent parliamentary session, you must have read various articles on that also regarding the monsoon session. There were a lot of controversy that the opposition was not allowing the government, that the party in power to work, and they were not allowing to, and the party in power, that is the present government, they were passing the bill in 15 minutes. In 15 minutes 21 bill was passed, something like that. I have read in some article, something was that in 15 minutes 21 bill was passed, or in 21 minutes 15 bill was passed, and the voting was done just by a voice voting. Okay, there are two type of voting. One is the voice vote, in which the speaker or the chairman says that those in the favor say yay, those who does not favor the bill, they will say nay. Okay, and if the yay is more than the nay, then the bill gets passed. If the nay is more, then the bill gets rejected. Okay, the bill does not get passed. Now this is the one way of voting, that is the by the voice vote. Okay, now I myself personally, I have appeared in the Jharkhand Yuva Sadan also. There also what I saw, I want to say, matlab, express with you all, share with you all, that what I saw there, that when the time came for the voting, then what did the party in majority? I was myself in majority in representing my constituency in Jharkhand Yuva Sadan. Now what the party in majority, they said yeah. Now what, who were in the opposition, they started to shout by a voice vote that nay. So there is issue regarding the voice vote, that because the see, now the chairman or the speaker, they know that what is the number of opposition, what is the number of party in power, that they know. But from a personal experience, I have seen that those who were in the opposition, although they were less in number, but they were shouting more. So it was appearing that that those in the favor of the motion was less, and those in against the motion were more. Okay, as a result of which one of the bill could not pass also, and I question on that this is not the way. But that is another thing. So this is one of the way in which voting is done in the parliament under say Article 100 of the Indian Constitution. Now second way of voting is the ballot voting system. Okay, means the ballot voting is the voting system in which they have to, the secretary of the Lok Sabha or the Rajya Sabha, they will, he or she will explain you how the voting has to be done. You just have to press the button, and then on the board you will be seeing that on the board it will be appearing yes equal to itna, no equal to itna, and accordingly that the vote is passed. Now that is one way. So these are the two way of voting in the House of the People and the Council of State. Another thing is under Article 100 is that the chairman or the speaker do not cast vote on the first instance. For example, there is voting in the Lok Sabha. So the 530 member, that is the maximum member, they will be voting, those in the power, the BJP has got whatever seat, 300 something, and those in the opposition, they whatever seat they are having, they will be voting. At that time, the speaker for the House of People and chairman of the Council of State, that is the Rajya Sabha, they will not be voting. Okay, now what happens, see, generally this does not happen. This is a very rare case, because sometimes it might happen. For example, I am taking the recent example of the caste based census. That is the thing, no guys, see, yesterday I have introduced one of the today he is not present because he's a very busy person. Yesterday I introduced you one of my colleague, that was Abhidip. Yesterday we have an introduction with him in the yesterday class. So there you must have what I was saying, that you must have seen that time also, that while the voting is done, that time the speaker or the chairman does not cast the vote, and generally this does not happen, that the chairman or the speaker need to cast his vote, because the thing is that those in the power, definitely those who are in the power, they are having more number of MP or MLA in the state assembly. So while the voting will be done, definitely the bill get passed by a majority. Now sometimes what happened, the alliance, let's see the recent example of the caste based census. For example, a caste based census is being bill is being introduced in the Lok Sabha. For example, I'm just giving an example. This bill will not be introduced because this is not a bill. So if the caste based census bill is introduced in the Lok Sabha, and it is being introduced by the present government only. Okay, we are changing the circumstances which is of now. It is introduced by the BJP government, for example, not the NDA government. It is being introduced by the BJP government, and the alliance of the BJP, like the from the Bihar you have the JDU, okay, and all the other, the Maharashtra is there, Ramdas Athavale party, okay, they are also there, and the opposition is also there. Now those who are in the BJP, they will vote, definitely they will be voting in the motion, for the motion of the bill. Now what happened, even the these people, that is the alliance of the BJP, that is the NDA, that is your JDU and Ramdas Athavale, they did not voted in the favor of the bill, they voted against the bill. They voted against the bill. In that case, there will be the institution of the disqualification of the disqualification, and then there will be some issue like that. That is the 52nd amendment. Certain time, what happens, that the number of votes that is in favor, okay, when there is a joint session of both houses of the parliament in which the Lok Sabha and Rajya Sabha both are together. In that time, certain time, what happened, that in the Lok Sabha the party in power is having majority, but in the Rajya Sabha they does not have the power. So when the joint sitting happen for a bill, when the joint sitting will happen, we will be discussing very soon. Now when the joint sitting happen, the number of yes is equal to the number of no. For example, the number of yes is 440 and the number of no is also 440. So there will be an equality of vote. In that case, the Speaker of the Lok Sabha, definitely, because it is a joint sitting of both houses of the parliament, the Speaker of the Lok Sabha will be the chair, will be presiding over the chair. So in that case, the Speaker is being given power under Article 100 that he or she will cast his or her vote, and then if he give to yes, then the bill will be passed. If he give to no, then the bill will not be passed. That is the thing under Article 100. Now, Article 102, that is the 52nd amendment, disqualification of being a member of the parliament. So if he holds any office of profit under the government of India, okay, if he has unsound mind and stands so declared by competent court, if he is an undischarged insolvent, if he is not a citizen of India, or has voluntarily acquired a citizenship of foreign state. When we have started the session in the beginning of the lecture series, we have discussed citizenship. In that I have told you that in India we have only single citizenship and not dual citizenship. We have only single citizenship. Now if any parliamentarian, okay, acquires the citizenship of Afghanistan, okay, if any parliamentarian at this point of time go and acquire the citizenship of Afghanistan, चले जाओ भाई, कोई दिक्कत नहीं है, मजे करो वहां जाके. At that time, what happened? He will lose his parliamentarian seat. He will no longer be representing the constituency, because he will no longer be a citizen of India. If he is so disqualified, by or under any law, in that case, okay, in that case, he will not be. If he is disqualified, then he will not be allowed to represent his constituency in the Lok Sabha. There is a case of Jaya Bachchan versus Union of India. We all know who is Jaya Bachchan. So Jaya Bachchan versus Union of India. In this case, what happened? Jaya Bachchan was a member of parliament, okay, and she was also holding the chairman post of one of the something related to the film in UP. Now she was the chairman of some film industry in UP, in Uttar Pradesh. Now the election was, someone is telling, I guess. Okay. Now election were held, and then she was elected to the Lok Sabha. Now someone challenged her election. In the Supreme Court. Her election was challenged, and that she was because it is under Article 102, it is mentioned that a person will be disqualified if he hold any office of profit under the government of India or the government of any state or other than the office declared by the parliament by law not to disqualify. So her election was challenged, and then her argument was that although the film industry gives the chairman a sum of rupees this much, whatever may be the sum, for example 1 crore, but Jaya Bachchan, does not take that sum. Supreme Court told in this case that, madam, no, that is not the thing. If you are under a office in which a money amount, pecuniary value is allotted to it, whether you take it or not, that is not of concern. Okay, whether you take that monthly payment or allowance, whatever is given to you as a part of the chairman of the film industry, that is not the concern. Our concern is that you should not be holding any such office which is having a monetary or pecuniary value attached to it. That was the reason given by the Supreme Court in Jaya Bachchan versus Union of State. Done. Now, Article 103 in the Indian Constitution. Just give me a minute. Yeah, film industry. Yeah. So, so Article 103 in the Indian Constitution, that is the decision on the question of disqualification of member. Now, if any member of the either house of the parliament has become to subject to disqualification under Article 102, the question shall be referred for the decision of the president, and his decision shall be final. Whether he should be disqualified or not is to be referred to the president by the speaker. The speaker will refer it to the president, and the decision of the president will be final. And another thing is that before giving any decision, the president shall obtain the opinion of the election commission and shall act according to such opinion. So president just is a nominal head, nothing more. Now this is Article 105. Article 105, that is the power and the privileges of the house of the people and the member that is given. So it tells that subject to the provision of this constitution and the rules and standing order regulating the procedure of parliament, there shall be freedom of speech in the parliament. Okay, in the parliament, just you have seen in the monsoon session, they were howling and shouting and raising all kind of slogan. Now at that time you cannot go and put a charge on the particular MP. They can be removed from they can be suspended from the house by the speaker or the chairman. Okay, but no criminal proceeding or something such proceeding can be initiated because they are given the privilege under the House of Parliament for the freedom of speech and expression. Okay. Next, no member of parliament shall be liable to any proceeding in any court in respect of anything said or any vote given by him in parliament or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of either house of the parliament. So just not what they are telling, that whatever you are publishing in any of the newspaper report or in the proceeding or whatever you are telling in the house, okay, they will not be none of the member will be liable for any kind of proceeding for such all this thing. So these are the privileges that is given. One more privilege is there, that when you are a member of the parliament, either house of the parliament, before 6 months and after 6 months, after the expiry of the 6 months, okay, means while you are having the tenure of 5 years as a member of parliament representing your constituency, and even after you cease to be a member of parliament, after that also for up to 6 months no proceeding will be initiated for your parliamentary actions. That is Article 105, that is privileges of the house of the people and the member. Now this comes the joint sitting of both house of the parliament. This is a very important article. Here you have to remember the article, that is Article 108. It is asked various times, that Article 108 of the Indian Constitution, that is joint sitting of both house of the parliament. So if after a bill has been passed by one house and transmitted to the other house, the bill is rejected by the other house, the house have finally disagreed as to amendment to be made in the bill. More than 6 months elapsed from the date of the reception of the bill by the other house without the bill being passed by it, the president may, unless bill has lapsed by reason of dissolution of the house of the people, notify to the house by message if they are sitting, or by public notification if they are not sitting, his intention to summon them to meet in a joint sitting of the parliament, provided that nothing in this clause shall apply to money bill. We are coming on this soon. So Article 108 talks about the joint sitting of the both house of the parliament. Now if a bill is being passed by the Lok Sabha and it has been sent to the Rajya Sabha, now if the Rajya Sabha rejects the bill, or the Rajya Sabha has disagreed for an amendment, or if 6 months has passed from the time when the bill was sent to the Rajya Sabha but no response has been given, then the president in that case call for it can give a notice, and he can summon the both house of the parliament and call them for a joint session of both house of the parliament, and the joint session of both house of the parliament will be presided by the speaker of the Lok Sabha. This is a very important polity question. The joint session of both house of the parliament is chaired by the Lok Sabha. Now we come to the money bill. So we know that the money bill can be introduced only and only in the Lok Sabha. The money bill can be introduced only and only in the Lok Sabha. Now it will be sent to the Rajya Sabha, and if the Rajya Sabha does not return the bill within the 14 days, then the bill will be considered to be passed by both House of the Parliament, and it will be sent to the President for his assent. What I told, that if the bill is rejected, if it is an ordinary bill, if it is rejected, if the amendment has been disagreed or 6 month time has been passed, then the President will call for the joint session of both House of the Parliament, which will be presided by the chairman of the Lok Sabha, that is the speaker. But this article, that is 108, will not apply to money bill, because we know that in money bill the bill can only be introduced in the Lok Sabha. First thing. Second thing, if the money bill is, when the money bill is sent to the Rajya Sabha, the Rajya Sabha is bound to return the bill within 14 days. The Rajya Sabha is bound to return the bill. Okay, the Rajya Sabha is bound to return the bill within 14 days. And if the Rajya Sabha does not return the bill, if the Rajya Sabha does not return the bill within 14 days, then it will be deemed to be passed by both House of the Parliament, and it will be sent to the President for his assent, and then it will become an act. Now, Article 109. Article 109 talks about the money bill. So, it is clearly mentioned that a money bill shall not be introduced in the Council of State, that is the Rajya Sabha. The money bill cannot be introduced in the Rajya Sabha. It has been clearly mentioned under 109. Okay. Now see, just what I have told you just now, it is given here. After the money bill has been passed by the House of the People, that is the Lok Sabha, it shall be transmitted to the Council of State, that is the Rajya Sabha, for its recommendation, and the Council of State shall within a period of 14 days from the date of its receipt of the bill return the bill to the House of the People with its recommendation, and the House of the People may thereupon either accept or reject all or any of the recommendation of the Council of State. After 14 days, the Rajya Sabha has to send back the bill with the recommendation, and the recommendation that is being sent by the Rajya Sabha or the Council of State, the House of the People or the Lok Sabha, they can either accept the recommendation or they can reject. They are not bound like the President, okay, to act on advice of the Prime Minister and Council of Ministers. They are not bound by the President. They are not bound like the President. They can either accept the recommendation, okay, they can either accept the recommendation or they can reject the recommendation. That is Article 109. Now Article 110 talks about that what does the money bill consist of. That is not of much importance. This is an important article, 112. Article 112, now generally we call the budget. Okay, we know that on 1st of February every year, on 1st of February the budget is introduced in our Parliament, है ना? Our finance minister, generally the finance minister, or if the finance minister is not present, in that case someone appointed on behalf of the council of minister, but he should be someone from the council of minister and not anyone. So that is the budget that we call, is called the annual financial statement. Nowhere in the Indian constitution, this is a polity question, that is budget mentioned anywhere in the Indian constitution? No sir. We have Article 112 which talks that the President shall, in respect of every financial year, cause to be laid before both House of the Parliament a statement of the estimated receipt and expenditure of the Government of India for that year, in this part referred to as the annual financial statement. In this part means part 5 of the Indian Constitution. We don't have the budget, no term budget is there. We have the annual financial statement under Article 112 of the Indian Constitution. Now what is the 52 amendment? We will be discussing when we will be discussing the 52nd amendment. Then we will be discussing it in detail. Now we come to the session of the Parliament. So session is what is session? That session is something where the Lok Sabha and the Rajya Sabha, that is the Parliament, they will meet. They will discuss on the various bill. They will discuss on the various bill. The bills will be passed. There will be debate, there will be discussion, there will be argument, there will be question from the minister has to answer. This whole thing will be happening during this session. So in India we have 3 sessions. Okay, in India we have 3 sessions. That is the budget session, the monsoon session and winter session. We have 3 sessions: budget session, monsoon session, which was in just we have within last week we have completed the monsoon session, and then we will be having the winter session in the November month. Okay, last year the winter session was cancelled because of the corona pandemic, you must remember that. So 3 sessions are there. Now the question, why I told you that last year, understand my point. Last year I told you that last year the winter session was cancelled. Why I told you this? Because the reason behind is that according to article, according to the session of the parliament, according to the constitution, only 2 session is compulsory in a year. Only 2 session is compulsory in a year, or in the other word, that the gap between 2 sessions should not be more than 6 months. So you can calculate very easily. You can calculate very easily. So if we take the example of 2020, we had the monsoon session in September. है ना? In September we have the monsoon session, August and September. Now from August, if you calculate, then August, November, December, January, February. On 1st February we had the budget session. So you see only 5 months was difference was there. So according to the Indian Constitution, there should not be a difference of more than 6 months between 2 sessions of the House of the Parliament. And the Indian Parliament, in the Indian Constitution state that 2 session is compulsory. Budget session, monsoon session, winter session or budget session, whatever it is, 2 session is compulsory. So that's why the winter session was cancelled, and there was no, it was not a much, not a big issue, because we have that provision in the Indian Constitution. After this, we start with the Indian judiciary. So we are done with the executive part. That is, we talk about the president, the vice president, the governor, the parliament, and and all such things. Now we come to the judiciary. So the first and the most important article is Article 124, that there shall be a Supreme Court of India. There shall be a Supreme Court of India consisting of a Chief Justice of India until Parliament by law prescribe a large number of not more than 7 other judges. This was at that time when the Constitution was instituted. At present, we have 34 judges. Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such judge of the Supreme Court and of the High Court in the state as the President may deem necessary for the purpose, and shall hold office until he attain the age of 65 years. As I have told you, that the judge of the Supreme Court will be appointed by the President. Now, whenever any appointment is made by the President, always remember it is on the advice of the Prime Minister and Council of Ministers. So, every judge of the Supreme Court will be appointed by the President with the consultation with the other judges of the Supreme Court and the judges of the High Court as he may deem necessary, and the judges of the Supreme Court hold the office for 65 years. You must have remembered in the last week that our present Chief Justice Sri N.V. Ramana, okay, he has recommended 9 judges to the Supreme Court, among which 3 are women. 3 are women, and if this continues, then most probably by 2027 India will be having the first woman Chief Justice of India. That will be a very big, it will be a very big issue, because till now India did not have any woman Chief Justice. So if this trend continue, okay, then in 2027 this she will be the first woman Chief Justice of India. So they hold the office of 65 years. Presently we have 34 judges. Article 124. Article 125 is talking about the salary of the judges, okay, and then Article 27, that is the appointment of the article, it talks about the appointment of the ad hoc judges. It talks about the appointment of the ad hoc judges, that if any time, if at any time there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, the Chief Justice of India may, with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned, request in writing the attendance at the sitting of the court as an ad hoc judge for such period as may be necessary of a judge of a High Court duly qualified for appointment as a judge of the Supreme Court to be designated by the Chief Justice of India. This is very important article, Article 127, that is the appointment of the ad hoc judges. If any time the Chief Justice found that for example, you see a constitution bench, the minimum number of judges that should be present in a constitution bench is 5. Until and unless a 5 judge sit, it will not be considered as a constitution bench. So if the Chief Justice finds that the quorum of the Supreme Court is not completed, then with the prior consent of the President and the consultation with the Chief Justice of that particular concerned High Court from which he is calling the ad hoc judges, he will in writing invite this particular judge to be a ad hoc judge of the Supreme Court for a period which for whatever period he or she thinks necessary. No, it is important to add she because in 2027 we will be having a female chief justice. So for whatever period he or she considered it necessary, but that judge of the High Court who has been invited to be the ad hoc judge, he should be qualified to be appointed as a judge of the Supreme Court. This is very important thing. Then we come to the very important article of the Indian Constitution, that is Article 129. You must remember Prashant Bhushan case in which our former Chief Justice Sarad Arvind Bobde was sitting on that very costly bike. Okay, and then on that Prashant Bhushan has tweeted that there is judicial so much of cases pending in India, and because of the pandemic, the courts are closed. Okay, and the people are not getting justice, and our chief justice is sitting on this amount, whatever was the amount. Just give me a minute. Yeah, so whatever was the amount, this amount, this costly bike, the chief justice of India was sitting on this. A contempt of court was initiated against Prashant Bhushan, and matlab he was very badly, his image was very badly tarnished by just putting a cost of rupees 1. So it was a very bad for Prashant Bhushan. And you must see that Prashant Bhushan always, he's on trend, okay, on the Twitter and everywhere, every time for the political issue or for the judges issue, for the Supreme Court issue, every time he is on trending. So Article 129 states that the Supreme Court will be a court of record and shall have the power of such court, including the power to punish for contempt of itself. Okay, very good, sir. When Lightning Dream organized the debate on Article 124, whether India is a free democracy, discussed in light of Section 124A of the Indian Penal Code. That time, I guess 2 or 3 of the participants, they told that just like the Supreme Court can punish anyone for his contempt, okay, why cannot the government has the power, okay, for the same under sedition law? So that was an argument. Now, what is whether sedition should be there or not should be there? I'm not going to that whole thing, but that was an argument I liked very much. That when the Supreme Court has the contempt power, then why not the Parliament when the government had the sedition power? So that is Article 129. This article is very important. Which article of the Indian Constitution talks about contempt of court? That is Article 129. Now this Article 130, seat of the Supreme Court. Recently one blog was uploaded on Lightning Dream website also, in which regarding the pendency of the cases was taken into consideration. Pendency of the cases were taken into consideration. There also this Article 130 was discussed that the Supreme Court shall sit in Delhi or in such other places as the Chief Justice of India may, with the approval of the President, from time to time appoint. This is a very big issue, guys, that many times various experts from the law field and the legal field, they have various time asked that there should be Supreme Court at Chennai, Madras, Calcutta, okay, Bombay. That is Chennai and Madras is the same thing. Bombay, Calcutta. These are the places where they are asking for a Supreme Court for certain time. So the Supreme Court will sit in Delhi, but if the President approves, then the Chief Justice, they may sit at other place or places. So Article 130 is very also important in view of the pendency of the cases in the Supreme Court. Okay. So law is something which you can connect. Okay. That only I was telling about that guy that I introduced yesterday. That see, he's also doing LLB, he's also doing BA LLB. But apart from his BA LLB, he is working as a social worker. Okay, he's working for as a he's the secretary of that legal aid cell of the Jharkhand. Okay, the legal aid cell of the Jharkhand, and for the social cause, another he is working. So you can connect the dot. You can connect this law and your personal, social, society life. All can be connected together. Law is a very interesting thing. Now we come to Article 131. That is the original jurisdiction of the Supreme Court. Sorry, those who are preparing for Clat, you must have come around this passage regarding the original jurisdiction of the Supreme Court many times. Subject to the provision of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between the government of India and one or more state, or between the government of India and any of state on one side and one or more state on the other side, or between two or more state. Original jurisdiction of the Supreme Court talks about the government of India and one or more state, that the government, for example, government of India, UP, state of UP are on the same side and Maharashtra is on the other side, or between two or more states. For example, you must have remembered the Krishna Godavari issue. Okay, Krishna Godavari issue in which the two state was in dispute, that the Supreme Court take the matter into consideration. So these are the three places where the Supreme Court has the original jurisdiction between the government of India and one or more state. Okay, between the government of India and one or more state. Then you have the between the government of India and any of the state on one side and one or more state on the other, and between two or more state, that is the original jurisdiction of the Supreme Court. This is also a very important article. Then you have the appellate jurisdiction of the Supreme Court, that is an appeal lies to the Supreme Court from any judgment, decree or final order of a High Court in the territory of India, whether in a civil, criminal or other proceeding, if the High Court certifies under Article 134A that the case involved a substantial question of law as to the interpretation of the Constitution. So appellate jurisdiction, as the name suggests, that an appeal can be made from the High Court to the Supreme Court, but the condition is that the High Court should certify that this matter it involved the interpretation of the Constitution. Now Article 136, you must have heard by if you have attended any of the webinar or seminar of the various jurists, you must have heard the SLP. Many times they tell that SLP. So SLP is the special leave petition, that is special leave to appeal by the Supreme Court, that is a special leave petition under Article 136. Notwithstanding anything in this chapter, the Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence, order in any case or matter passed or made by court tribunal in the territory of India. What does it tell? That the Supreme Court may allow a special leave petition to be filed in the Supreme Court for any judgment, degree, determination that has been passed by any court or the tribunal. So special leave petition is under Article 136 of the Indian Constitution, that you have to remember. Now, very famous judicial review. You must have come across this article, passage on judicial review in your Clat preparation also. That is Article 137, review of judgment or order by the Supreme Court. Subject to the provision of any law made by Parliament, the Supreme Court shall have the power to review any judgment pronounced or order made by it. The Supreme Court can review the judgment that has been made by it under Article 137. That is the review power of the Supreme Court under Article 137. Then we have Article 41, law declared by Supreme Court to be binding on all courts. So any law which is declared by the Supreme Court, okay, it will be binding on all court within the territory of India. For example, you take the example of the Vishakha guideline. The Vishakha guideline, that is the Sexual Harassment of Women at Workplaces Act 2013. So the act was brought into force in 2013. But the Supreme Court in 1990 or 1997, something is 1997. The Supreme Court at that time only has given the guideline for the sexual harassment of women at the workplaces. Okay, that time only the Supreme Court has given the guideline for the sexual harassment of women at workplaces, in which the Supreme Court declared that what should be the way in which the internal committee should be formed. Okay, how many women members should be there, how many male members should be there. So similar thing is there, that any order or any judgment that is passed by the Supreme Court, all the court in the territory of India should bound by it. If the Supreme Court tell that Sabrimala, the entry of women will be allowed, the Kerala High Court, the Kerala District Court has to follow that judgment. So any order which is passed by the Supreme Court, any judgment which is given by the Supreme Court is binding on all courts within the territory of India. That is Article 141. This is also a very important polity question. You will get this question many times when you are solving any of the polity question. Yeah, just last article of the Supreme Court, that is the power of the President to consult the Supreme Court. Under Article 143, if any time it appears to the President that a question of law or fact has arisen, then he can accept to get an opinion from the Supreme Court. But whatever opinion is being given by the Supreme Court, he is not bound. The president is not bound to take the order or the opinion that is given, not the order, the opinion that is given by the Supreme Court. So under Article 143, the president may consult the Supreme Court. The president may consult the Supreme Court, but the opinion that is given by the Supreme Court for a matter of question of fact or a matter of question of law, that is, it is not compulsory for the president to take it into consideration. So we'll stop here, and from tomorrow we will be dealing with the amendment, the various important amendment, and the last part of this will be the schedule, the important schedule of the Indian Constitution. So just these two important things are left, that is the amendment and the schedule. So we stop here. We will meet tomorrow. Okay.